Let's pick up from where we left off, talking about the conversation with Professor Mohammed Taufik Ladan on access to juvenile justice in Nigeria. Okay, Prof, I'm glad you're back with us. Now, you were telling us on how Nigeria is signatory to the Convention of Rights of Child and how to correct the perception that Nigeria has not done well, the Nigeria system, when it comes to juvenile justice. So, go ahead.
Thank you very much. I think in the first instance, we need to correct the impression that successive governments have not done enough with regards to juvenile justice or child justice administration in Nigeria. Let's actually look at the non-existent before 2003. There was no comprehensive child rights law in Nigeria until 2003, which seeks to actually, address all the international treaty obligations of Nigeria on how to protect, promote the rights of children, because children are vulnerable. And the reason why they are vulnerable are essentially four, and that is they are largely discriminated against, they are marginalized, they are disadvantaged, and then they are also largely excluded from participation in the decision-making process affecting their lives in society. So what the federal government has done since 2003 was first to enact a Child Rights Act, a comprehensive legislation to protect the children, and for the first time to create, a conception that moves away from juvenile justice to what is now called child justice administration in Nigeria. It has to be a friendly system, and then it also created a family court system at two levels, at magistrate level and at high court level. And this instrument has been adopted by 29 states of the Federation out of 36. And the reason for this is important, i.e. states also have child offenders under their laws, so they should be able to have similar laws that will also address and protect children and provide for juvenile justice. The truth of the matter actually is that, this law was supplemented by a national child policy, 2007, and implementation guidelines of 2008. All these are legal and policy instruments that have been put in place that requires funding, requires commitment and cooperation, with all the justice sector actors in Nigeria, including state and local governments. This is actually the crux of the matter. It requires funding regime from both state and federal government in order to actually ensure. Yes.
Okay, Prof. Of course, we know we also have the Children and Young Persons Act 2 that seeks to provide welfare for children and treatment of offenders. But from what you're saying, there's still abuse of rights of children. Now, for children who fall victim of circumstances, what kind of justice dispensation? Because you talked about administration of justice, it has been modified. So what kind of administration of justice should be given?
I think this is a very important question, and it's also part of what we call the implementation actually component of both the law and the policy that are already actually on ground. So our problem is the implementation. We need to establish appropriate child offenders institutions, or if you like, child justice institutions. And we also need to provide access to justice to child offenders. And children that are already vulnerable cannot access justice in our judicial system without financial assistance and without legal aid. These two key elements are important for them to access justice. So Section 46, subsection 4, paragraph B of the Constitution puts the obligation of the National Assembly to trigger the clause of providing a fund where all vulnerable and indigent citizens, including children, seeking to access justice, to have access first to financial assistance, and second, to also have access to legal aid, so that they can actually, access justice in any setting in Nigeria. Okay, the second actually point has to do with the fact that we need to have appropriate institutions for child justice administration to address child offenders' needs. And that actually is very important. Okay. We have to actually move away, from the postal homes. Yes.
Prof, very briefly now, just of recent, there was a forum constituted, to address access to justice for children in collaboration with the Federal Ministry of Justice, the European Union, UNICEF was part of it, and the Nigeria Police, and European Union, of course. Now, how would out-of-school children benefit from this?
Well, in the first instance, out of school children, there are almost about 9.1 to 10 million naira, to 10 million actually, peoples or children are part of the vulnerable children, that they all seek protection and they all seek, child justice system, and they also need access to justice. So children that are out of school, are already having a legal and policy backing for their protection. What they need actually is implementation with funding, with actual institutional mechanism in place at both federal, state, and local government levels, and political will on the part of government at the local, federal, and state level to ensure that their implementation strategies are child-friendly. That is one. And second, they also need to recruit people, social workers, and other justice sector actors at all levels of governance to ensure that they understand the new philosophy of child justice administration and why we are promoting also non-custodial sentencing for all actually offenders, including children. So out of school children need actually financial intervention on the part of all levels of governance, state, federal, local government. And then we also need all actually social workers and child justice actors to understand the new philosophy in the Correctional Service Act 2019 and also why the Child Rights Act 2003, adopted by 29 states, require that we must put in place family courts away from the regular courts so that it will be child-friendly environment for justice to be done. Out of children actually, need educational institutions, and they also need anti-poverty intervention actually measures. So these two, can all benefit from the policy and institutional mechanism that are already in place, but they need fine-tuning, and we also need political will. That is the crux of the matter. Political will is key.
Yes.
You need investment really in that respect.
All right. Prof, I'm very sorry, we have to stop there. Thank you very much for your time. Of course, a paradigm shift in the dispensation of juvenile justice is what we hope for. Thank you for your time.
Thank you. I'm grateful.
Okay.